I'm Paul Verkyle, Chairman of the Administrative Conference of the United States, which is a really great agency of government celebrating its 50th anniversary, and I have all my supporters, great government employees right there in the back row. Stand up, please. All right. So today's topic is a confounding one, complicated to the point of confusion. It's hard really to find a starting point. There is no originalness argument, since the idea of a professional government was unknown at the founding. The spoils system reigned through Jackson and Lincoln administrations, as those of you who saw the movie Lincoln would readily recognize. And when the Pendleton Act was passed in 1883, it wasn't until Teddy Roosevelt became civil service chairman in the early 1900s that it became a reality. Read Doris Kearns Goodwin's Bully Pulpit on that score. It's an amazing story. And by the way, Pendleton is an interesting figure himself. In the movie Lincoln, of course, he's the Democratic leader opposing Lincoln to get the 13th Amendment passed. You may recall him in that. But he appears later. He runs a railroad for several years in Chicago, comes back as a senator, and maybe thinking about what Lincoln did to him, passes the Pendleton Act. Interesting figure. We've moved far in the years since then, of course, and the key limitation now is what's called, quote, inherent government functions, which may not be outsourced. That's at least at the federal level where the action is. But that's really a contested proposition. Just read OMB Circular A76 and tell me if you can figure out which side of the line you are on in that regard. Still, it draws a crucial, and I would say, and others would say, even a constitutional line that your panelists can help define today. For our part at the conference, we have addressed ethics issues surrounding the use of government contractors who, in the nature of things, owe a duty of loyalty to their employers, not necessarily Uncle Sam. In law and economics terms, this is an agency cost problem. Our recommendation 211.3 says that contractors should be bound by ethics rules applicable to federal employees concerning personal conflicts of interest and the misuse of government information. DOD recently proposed an amendment to the federal acquisition regulations in this regard. But the inquiry today is not limited to the federal level. In fact, states and cities deal with the problem on a regular basis. Prisons and charter schools are two of the prime battlegrounds. And I would add another dimension. There is a movement at the state level to undermine, if not eliminate, civil service protections and professional government. Try that on if you are looking for people who want to speak truth to power. 28 states now have gone to at-will employment for state officials. Unfortunately, because of public union issues, this has become a political proposition. But the progressives and the conservatives alike have an equal stake in well-run government, and it is our job to make that case today. So I'm pleased to have, and honored really, to have this great series of panelists. What we're going to do, I'm going to pose a question, going to get a 5-minute answer from each one, and then maybe we'll have a little discussion among ourselves, and we'll throw it open for questions, if that works for everybody. So Reuben Guttman is director of the Grant and Eisenhofer law firm, adjunct professor, Center for Advocacy and Dispute Resolution at the Emory Law School. And he gets the first question. Okay, what are the central questions and concerns that increased privatization present?
Well, I'll do what everybody in Washington does, which is take the question, rephrase it, and talk about something else.
Be my guest.
I'm just kidding you. First of all, I'm a board member of ACS, and actually I put the panel together because I wanted this to be a catalyst for people to think about this issue. I want, see, it's the first thing. wanted this panel to be a catalyst for thought about this issue, dialogue, and potentially some study and action. The important people in this room are not us. The important people are you people, the people who are the law professors, the law students, the people who are going to go talk to each other after this panel and think about litigation tactics and strategies and dialogue that they're going to have on the Hill. People like, obviously, Alan Morrison, my brother, who's written about this, Mike Kanovitz, who represents whistleblowers in Chicago, you know, Cookie Poplin, who's a doctor and deals in the false claims area. Before I answer the question, what I really want to talk about is what we mean by privatization, what the extent of privatization is. Everybody knows that we buy aircraft carriers from, you know, a big defense contractor. We know about the military-industrial complex. We know in the 1930s or 40s when we got into the Manhattan Project, we had DuPont, you know, scaled up to develop the Hanford Reservation. That's completely obvious. What we really haven't thought about is the extent of privatization of our government, that really who is running government. First of all, we think about government, we think of ACS, we think about this impartial entity that's going to be fair, that's going to be unbiased, that's going to be subject to civil service regulations, it's going to be subject to appointments and controls and conflict of interest rules, organizational conflict of interest rules. That's what we want our government to be. On the other hand, there's this tension where people say government doesn't work, and so let's turn government functions over to the private sector. And we hear this concept called free enterprise. Free enterprise was Henry Ford, who, you know, developed, you know, the car and mass production. Free enterprise was, you know, the fact that we have Hershey chocolate bars. That's free enterprise. It's theoretically all good stuff. But free enterprise is also Enron, Tyco, WorldCom, and more recently General Motors. And if you're Ralph Nader or my brother's age, you remember that this is just, you know, variations of a reoccurring theme with General Motors. And these corporations are obviously undoubtedly run by temporary caretakers. So they have their own motivations, right? Okay? And then the question is, when you put corporate America together with the government, are you really talking about free enterprise? Are you talking about something different? Okay? You have companies like Lockheed who have violated Federal False Claims Act zillions of times, engaged in all kinds of fraud, engaged in, you know, violations of the Clean Water Act, Clean Air Act, across the board, and yet they continue to get government contracts. And when I, from my perspective in the false claims arena, engage in settlements with these companies, what you see is a settlement that has the optics of a large number, but in effect may be just the price for a license to continue to break the law. Pfizer, for example, a number of years ago paid $2.3 billion to settle pharmaceutical fraud allegations with the United States government. It's a major settlement. But when you actually look at the revenue stream for the drugs that were in question, the company made about $125 billion off of those drugs. Okay. I want to talk about the instances of privatization, hopefully to set this up that you haven't thought about. Think about the courts. You say, oh, courts are too slow. Let's go to arbitration. We are privatizing our court system. People don't think about that. But arbitration effectively is the privatization of the court system. It's the elimination of the common law, our common law tradition. There's no obligation that the arbitrators have to be bound by precedent. They don't have to publish opinions, and the review is very difficult in terms of getting it overturned. Let's talk about regulation. We have contractors that are actually involved in advising agencies on regulation. Classic example is a company called SAIC. A number of years ago, my brother and I were involved in litigation, environmental litigation, Oak Ridge, Tennessee, stemming from the recycling of radioactive nickel. And we challenged the recycling on environmental grounds, and there was no environmental impact statement for putting this recycled nickel into commerce. It turns out that the recycling was being done under contract with British Nuclear Fuel and SAIC. So contemporaneous with this contract, my brother went up to testify at the Nuclear Regulatory Commission with regard to the NRC's standard for free release of radioactive metal into commerce. And he said, by the way, you guys should know that the company that you have advising you on the regulation, SAIC, also stands to benefit because they have a contract to put this type of metal into commerce, conflict of interest. 4 years go by, I get a call from the Justice Department, we want to talk to your brother, we're ready to prosecute SAIC. It turned out somebody listened. The NRC never really thought about the fact that this private entity actually had an interest, right, in the regulation. So nobody realizes The thing about this SAIC case is the underlying fact. People don't understand that private actors are actually being involved in regulatory decision-making, regulations that have the force and effect of law. So that's the SAIC case. Two more examples before I turn it over, because I really want to get a dialogue and hear from everybody else. We all know that in order to put a drug on the market, you have to get an indication for the drug. The FDA gives you a specific indication, meaning it tells you how the drug can be used, what specific disease state, and so forth. What we don't know is, most people don't know is, Center for Medicaid Services is in charge of paying, right, for prescription drugs. They are a third-party payor. And what CMS does is they contract out the decision-making in terms of whether a drug is paid for, right, to the insurance industry. And the insurance industry, a private actor, pays the bill, but the insurance industry will actually pay for non-indicated purposes as long as the non-indicated purposes are supported by what are known as compendia. Well, there are these private actors, Thomson Reuters, that also do work for the pharmaceutical industry, that publish these compendia, right? And if you actually look at the doctors who are on the committees that are looking at the alternative uses of these drugs, in other words, the non-approved uses, these are the same doctors who are on the payroll of the big pharmaceutical companies. So effectively, you have a whole different backdoor mechanism, right, to, right, put drugs into the market and actually get them paid for by the United States government. And those are two classic examples. The third example that I want to give you is actually one that really should resonate with this audience. And my colleague, I was talking about this ACS board meeting yesterday, Judy Scott, who's the general counsel of SEIU, her daughter Sarah Stillman, she told me to hold this up, just wrote an article in the New Yorker about the privatization of parole services in the United States. Well, think about this. So there's a trend to say, we don't want to put people in prison, so we'll have people out on the street. So these companies have made a business of saying, oh, well, it costs money to monitor these people who are on parole, right? So we will go to municipalities or go to the judges and we'll say, we'll do this for you for free. We'll collect the money, right, from the parolees. So in the state of Georgia, turns out you have people on parole for traffic violations. So these companies go and they collect money from these folks and they sell them, they require them to have monitoring bracelets because they're also in that business, as if somebody, you know, who's got a traffic violation is going to skip town and go to Mexico because they're worried about it, right? And at the end of the day, they can't pay the bill, and these private actors, right, with the force and effect of laws, parole officers sign a warrant and use the state of Georgia prison system as a collection agency. In Georgia, 3,000 people have gone to prison. So what I'm telling you is we, and this is about the extent of my intellectual capacity here is to outline the problem for you people to think about and come up with solutions, whether they are constitutional or otherwise. What I am telling you is that we think about ACS in terms of the importance of having independent government, a constitution that's give us sort of this, the scales of justice, independence, impartiality. And I'm telling you that at some level, the basic functions that we think are so important, the function of actually implementing and putting together regulations, how we treat our prisoners, the basic court system, right? Contracting out in terms of privatizing through arbitration, right? This, we are gradually losing that. And the final point, before I conclude, absolutely the final point, I promise you this, is that at the end of the day, the biggest problem is our government has no ability to engage in oversight over these contractors. You will see bank settlements of $25 billion or $10 billion or $1 billion. You will see pharmaceutical settlements of $3 billion. And the government will issue a press release and say, this is monumental. Well, I will tell you that they also, at the same time, applaud themselves for collecting $2 billion or $3 billion a year from the pharmaceutical industry. They also project that out of the $500 billion in spending, there's $80 billion in fraud, $80 billion in fraud. So we're in a situation where these companies are, these private actors, effectively, when they get caught, are paying for a small fee for the license to break the law. And so we have a compliance enforcement problem with regard to how we deal with these private actors.
Thank you very much, Reuben. That certainly should provoke us. So now let me go to our second panelist, John Michaels. John is a professor of law at UCLA and is visiting at Yale this year. And John, my first question for you is, to explain why government is special and should not be run solely as if it were a business. Yeah,
We might be short on power. Thanks, Paul, and thanks, Reuben, for inviting me as well. It's right now. It's one of the questions is, as Paul framed it, is why shouldn't government be run more like a business? And I think that's a problematic framing, though it is the conventional one at this point, and one that defenders of the state, defenders of the traditional state, as we define it in 20th century modern kind of administrative and constitutional law, often find themselves on the defensive. So I have some thoughts on both why the government is special and the ways in which it's becoming less special, both through privatization and through the internal changes as the government itself kind of adopts, if we can kind of anthropomorphize the government, adopts this kind of consciousness that we should be more like a business. So one issue that I just want to put on the table first is that organizational structure is not the kind of end-all and be-all to think about. Think of the state has coercive powers, so the state might have to act differently. The state has to take in a kind of shared community in the way a commercial enterprise doesn't, that we have Republican commitments to inclusiveness and pluralism, and also stronger commitments or just simply different commitments to rule of law that might require more accountability, checks and balances from different stakeholders in a way that, arguably it's a different conversation that corporations might want to be more conscious of. But that, again, is a separate conversation from, let's just assume that corporations, everything's hunky-dory in corporate governance world, which I leave as a question. But the state has to act differently for those reasons, that it does exercise coercive force, that it is part of that it is representing a shared community. Now, with that in mind, I want to talk quickly about one of the ways in which privatization is more than just about, let's say, neoliberal efficiency. It's also about control. Control that is second nature in most corporate governance context, but I find highly problematic in the sphere of the administrative state and within agencies. And so this is something that Paul already alluded to, but to the extent that you hire a contractor, you're most likely replacing or not hiring a new civil servant. And that matters in terms of, as most of the discourse is these are better motivated employees who have opportunities to kind of rise in their corporations or share in profit schemes in a way that's not true in the civil service, where you have lockstep salaries. But there's another element to it as well, which is, again, Paul alluded to this, which is the tenure. And tenure of civil servants is a very controversial issue these days, but it was a landmark achievement, and it enabled essentially an apolitical bureaucracy to develop to resist some of the, let's say, arbitrariness, the vast swings between political administrations or any hyper-politicized agenda, and to smooth out changes over time, and essentially to say, no, we understand you have kind of a political mandate to do something, but it doesn't follow the best science, or it's completely inconsistent with what Congress has directed us to do. And because you're not subject to political hiring or firing, you have some license to do that. And at various times, we've seen very heroic acts by the bureaucracy. Those often get overshadowed by the stories of kind of listless, bureaucratic, torpor, all the types of issues that that are conventionally or at least kind of popularly suggested about a less motivated, salaried bureaucracy. So this issue of control. So you hire a contractor. That we usually think about contractors. We're worried about, oh, they're going to run away and do something. They're going to go off on a frolicking detour and spend the government's money. There's another problem is they follow the political leadership's directions too closely and don't say no and don't resist. Why? Because they want to get hired again. Because they want to make their bonuses, which would be much more likely to happen as long as they're kind of nice players with the administration in a way the civil servants has no strong incentive to do. So that's one concern, is that it's not just about economics or neoliberal economics, it's also about a form of control. The second, again, something that Paul prompted thinking about, is the way in which the government is internalizing this idea. And in previous writing, I've termed this the marketization of bureaucracy. And essentially that not only at 28 states, and it's happening increasingly in the federal government, is that people have started to say, hey, this contracting idea is great. why don't we simply remake the government workforce to look like a contractual workforce? We'll reduce pensions, we'll reduce collective bargaining rights, we'll take away tenure, as it's done in 28 states. There's a new proposal to do it with the Veterans Administration. There's a pending rule by the Office of Personnel Management that would allow the administration to essentially designate folks that are in any way kind of remotely related to national security, to designate them as at-will employees for purposes of control. And this is really undermining the civil service from within. So you have the force going out, you can just sideline the civil servants, or you can change the nature of government work. All of this is creating a vicious cycle where government work at the bureaucratic level is becoming much less desirable. You have more political control, you have less perks, less esteem. And then when bureaucracy doesn't seem to be working well, we say, aha, let's gut it further. So I'm concerned, that's an issue to be concerned about going forward as well. And the third, I guess, is more of the kind of normative question that Paul was prompting. And what should we be worried about with what I would consider is, to some degree, the moral erosion of the state? And it's the combination of the kind of the commercialization, not just by using contractors, but also the way government reorganizes itself, and not just with the bureaucracy, but think about kind of the conflicting or complicated mandates of the Postal Service or Amtrak, where they're supposed to serve kind of core public functions, distributive public functions, redistributive public functions even, but also supposed to turn a profit. And how are they supposed to negotiate this space? Or think about when the federal government took controlling shareholding interest in AIG and the automotive companies. Well, what are they supposed to do there? Are they supposed to maximize shareholder value for the taxpayers? Are they supposed to use their directorship to prop up the company, to prop up the larger political economy, or to engage in an alternate form of regulation? And they did a little of everything. So the government directors of the automotive company said, well, we want higher clean energy. We want higher proportion of your fleets to have clean energy. We want you not to close down a certain number of plants in America. Well, it sounds like environmental policy. It sounds like employment policy, all things that many kind of good standing members of the ACS probably approve of. But they didn't go through statutory through the kind of bicameralism presentment. They didn't go through notice and comment rulemaking. They went because they they did it through 90% control over the board of directors. And recently, and I think Kimberly might be talking about the Amtrak case, so I won't get in too much to it. But Amtrak, there was a case decided last summer where Amtrak is supposed to run for a profit. It's also supposed to regulate the larger kind of space of shared tracks. And the DC Circuit was concerned that they were engaging in self-dealing because they would give themselves priority over shared tracks, presumably because Congress is expecting them either to turn a profit or not lose as much money. So I would just encourage people not to think about privatization simply as an external force, but as a dynamic that is both external and also influencing the way government itself operates independent of privatization. I would also encourage folks to think about ways in which the civil service can be strengthened, fortified, supported in ways that I think is very difficult, really briefly, because most law students, most elites in the United States want to be, when they first start out, want to be special assistants to the secretary of something. They don't want to go, or the special assistant to the special assistant to something, as opposed to going into the bureaucracy. That hasn't always been the case. It certainly isn't the case in other countries. I can understand why you would not want to work in the bureaucracy if at 25 you could be the person who tells the 40-year-old expert what to do because you sit outside your boss's office and he or she is the secretary. But it's something to think about as kind of a long-term problem that needs perhaps just small incremental fixes.
Thank you, John. That's very, very helpful. And by the way, John mentioned the VA legislation. Are there any government, other than my group, any other government officials here? Great. So the VA, quickly, this is VA case is because of the terrible problem of lying about waiting times, and you know all about it. But the solution is to give Congress the ability, through legislation, to give the agency the ability to get rid of SES and other government officials, and essentially just fire them, even though they are used to having a variety of protections. And the MSPB, Merit Systems Protection Board, which does hear cases of SES being removed, is told that under this legislation that you have 7 days to appeal to the MSPB if you're removed, and then they have 21 days to decide your case. Now you explain to me, how are you going to have discovery? How are you going to even have due process if it's an issue? It's a very interesting statute, and it was actually a compromise, and Senator Sanders put that in as a way to protect the government officials. On to the next speaker, and it's about time, I think. We need a little bit weighing in the other direction here. So Miriam Seifter, who is at Georgetown, but just recently got an appointment at Wisconsin Law School, for which we congratulate her. Would you talk about how privatization can work? Give us some examples, maybe, that are reassuring.
Yeah, do you want to switch mics back?
Oh, absolutely.
Okay, scarce resources here. Thank you, Paul. It's great to be here, and thanks, Reuben, for inviting me. So I do want to address this question of whether and how privatization can work. And to do that, I want to talk about an example that I've studied involving the privatization of hazardous waste cleanups and tell you why I think it went wrong and what lessons we can draw from that. But before I do that, let me just preview the broader message of my answer here, which is that if you're going to evaluate the wisdom and the likely success of privatization, you need to look at the design of a particular privatization initiative rather than just asking whether the actors involved are public or private. What do I mean by design? Well, privatization initiatives, including those that we've talked about here already today, vary a lot, just like public programs vary a lot. Some privatization initiatives, maybe some of the ones that Reuben mentioned, really are set up in a way that seems to invite poor performance. They have conflicts of interest built into their very structure. They sort of point to the profit motive in the wrong direction and encourage bad behavior. But there are other privatization possibilities, ones that create better incentives and have a greater likelihood of success. So I think that how a particular privatization program is structured really goes a long way toward answering this question of whether privatization can work. So to figure out what the design of a well-functioning privatization might look like, let's take my example. I did a case study a few years ago of a privatization program that some states use to do hazardous waste site cleanup. In the states that use this scheme, a regulated entity that has a hazardous waste problem, rather than going to the government like you would normally assume either in the federal system or in other states, they have to hire a private consultant who is licensed by the state to supervise and ultimately certify their cleanup. There is no option for your regular sort of plain vanilla government oversight. You have to hire this consultant. And because it's the regulated entities who get to hire and pay and potentially fire these private consultants, I call this model of privatization rent-a-regulator. Now, these privatized programs certainly have benefits, and there's literature praising them, largely because they really return polluted sites back to productive use more quickly. So, it may have taken decades to complete a whole cleanup process under the public model, and under this privatized model, sites were getting back into effective use much more quickly. But my study asked a different question, and that was simply, were the sites actually getting cleaned up consistent with the regulations that governed? And the answer turned out to be not really. So in the 3 years leading up to the study that I did, it turned out that actually about 70% of the sites that were cleaned up through this privatized program had failed to meet the regulatory standards in ways that were deemed through an audit process not to be de minimis. So these were significant violations of the regulations. Now, with that sort of quick overview of this study, I want to mention a few of the salient design features that I think sort of may be generalizable and maybe things to watch out for and be wary of. The first is privatized programs need to create the right incentives. You need to be aware of conflicts of interest, and you need to be mindful of the profit motive and which way it's pointing in the particular initiative under study. So one reason the program I studied had this pervasive regulatory slippage was that it had two built-in and relatively significant, I think, conflicts of interest. One, perhaps the slightly smaller one, was that it tended to be the same consulting firm that both performed and then approved the cleanup. So sort of natural conflict of interest there. But really the larger conflict of interest was this rent-a-regulator model where it's the polluter who gets to select, hire, pay, supervise, and potentially fire, if unhappy, this private regulator. Very much a sort of lawyer-client kind of model. And it seems that this just naturally created incentives for the private regulators to be cutting corners, to be essentially trying to please their clients in ways that undermined adherence to the regulations. So managing incentives is the first key. And then the second, and this has already been mentioned, is that these privatized programs need to create systems for monitoring and also for enforcement. So another problem with this program I studied was the lack of any real monitoring of performance or any meaningful consequences for poor results. This is sort of this irony that's raised in the privatization literature, which is that to have a successful privatization initiative, you actually need really strong public management. And the problem in this program that I studied was a lack thereof. The state had essentially stepped away and wasn't looking over the shoulder of the private regulators and didn't have a good system in place to respond. Certainly didn't have a well-funded system in place to respond if there was a significant problem. So I guess to wrap up, answering Paul's question about whether privatization can work really requires attention to context and design, in my view. It's not enough to say that that a program has gone private and therefore is going to fail, or the flip side of that, that it's public and it's going to succeed. I do think that the private programs that have the best shot of success are the ones that are mindful of incentives, that guard against conflicts of interest, that channel the profit motive in a way that helps regulatory adherence rather than undercutting it, and that do provide for this public role of monitoring and potentially enforcement if necessary.
Very nice. Thank you so much. And that really does give us something to think about, actually tools of analysis, very useful. Kimberly Brown is going to speak as the final speaker. And she's an associate professor of law at the University of Baltimore Law School. So Kimberly. Let me give you my
Other question.
Oh, is yours?
I know it, but that's okay.
I mean, you could ignore it like Reuben, but it's all right. What's the basic constitutional structure we are confronting when government functions are privatized? Need my?
Yes,
Mike?
please.
Oh, okay.
Hello? Is it working?
Okay.
Hello? Is that okay? All right, great. Okay, so first of all, let me say that there is no general federal doctrine against privatization. There's no doctrine requiring that government do the work of government. In addition, there's no broader theoretical principle to guide questions about alterations in the structure of government. So for those of you who remember the 90s film Speed, when crazy Dennis Hopper puts a bomb on a city bus, right? And then Keanu Reeves and Sandra Bullock have to essentially make steering adjustments because if the speed goes too fast or too slow, then the bomb will explode. And privatization, I like to think of, is similar to that, in that the bus is moving, and so the question is, what adjustments can be made to avoid a catastrophe? Then the question becomes, is there a catastrophe that will happen here if the Constitution doesn't step in? Can privatization be cabined through regulatory, statutory initiatives, contract terms, et cetera? Or does there need to be some more rigorous constitutional analysis on the table here? And I think the answer to this, and I roll all the law students in here, is it depends, right? On the one hand, if you have a general service contract for building maintenance at the Smithsonian, of course there aren't any constitutional questions at stake. But on the other end of the spectrum, as we've heard this morning, government outsources policy making, a power to make regulations, for example, or the power to implement regulations like military ops in the battlefield. And in that instance, there can be constitutional implications for at least two reasons. One is there can be an impact on civil liberties. And not to pick on Lockheed Martin too much, but say Lockheed Martin makes a benefits determination. Jane Doe has her disability payments cut off by Lockheed Martin, who is under contract to make these determinations. It's likely that the due process clause would not apply to limit the way in which that Lockheed Martin employee makes that decision, whereas if that decision were made on the same facts under the same law by a government agent, she would have due process protections. Now, there might be procedural protections in some other source of law. It just wouldn't be the Constitution. The second way in which there could be constitutional implications with the outsourcing of policy making or policy implementation has to do with government accountability, public accountability, which we've heard about already. Two aspects of this. One is, how do you hold the private sector accountable? There are issues with respect to compliance and enforcement, as we've heard, government rules relating to transparency, public participation, pay caps, conflicts of interest, limits on political activity don't apply with equal force, if at all, to the private sector. And as we heard from Reuben, there are lots of accounts of poor government oversight of contractors and fraud. On the other hand, there's also an issue with respect to government accountability, which we've also heard about. Chain of command is harder to discern when government outsources its powers, and as John mentioned, there's an incentive by contractors to get their contracts renewed. It's a very competitive market right now. They're arguably less likely to push back on higher-ups within the government. So is there a way to constitutionally require that these systems be better designed? If there are constitutional questions, is there a way that the Constitution can function as a backstop to at least force some better reforms in terms of ensuring adherence to civil liberties and accountability that are not just a matter of political will and good contract drafting and sufficient hiring at the government level to make sure that contractors are actually complying with their obligations under the contract? So what constitutional principles then can be brought to bear? As I mentioned, this is an ad hoc analysis at this point. There is the Supreme Court hasn't articulated any coherent framework for making decisions relating to changes in government structure, and no single doctrine is the shotgun in the closet that's going to help at this juncture. So it is a place that's ripe for creative lawyering. And I'll outline 5 lines of analysis to think about. The first is the state action doctrine, under which the court, even though the court has said for a long time that the Constitution, with perhaps the exception of the 13th Amendment, only binds public actors. It does not bind private actors. But the court will pierce the private veil, if you will, in certain circumstances, including if there is evidence that the government has retained control over the party to which the authority has been outsourced. The problem there, of course, is when there's a lot of discretion and little control outsourced, state action doesn't come into play to be able to hold that private party constitutionally liable. The second line of analysis is known as the non-delegation or private delegation doctrine. The theory is that constitutionally vested powers have to stay in the respective branch of government. This was used with success in the 1930s in litigation involving the New Deal. It's largely been sidelined for a long time, except, as John mentioned, last year out of the DC Circuit, the court revived it in a challenge involving the Amtrak Corporation, which is a government entity. The court has held it's a government entity for purposes of the First Amendment, but the DC Circuit said, no, actually, it's private for purposes of non-delegation, and in this instance, it has too much power. So that case, Association of American Railroads versus Department of Transportation, offers some potential avenues for further litigation. The third doctrinal route goes hand in hand with non-delegation in a case from the 1930s, and that's due process, or what I think the DC Circuit probably properly called in the Association of American Railroads case an echo of due process, and that is that private parties can't regulate each other if they're purely self-interested. So there's that line of argument picked up again in the DC Circuit. The fourth one I will identify under the umbrella concept of separation of powers / structural constitutionalism. And this has come up primarily when Congress has tried to create independent agencies or agencies that are divorced of executive branch authority. So from the vesting, the take care clause, the appointments clause, there are arguments to be made that outsourcing relationships violate the structural constitution to the extent to which they impede accountability for the exercise of government functions. Power comes from the people. It doesn't magically become not the people's power just because someone contracts it out. So there has to be some tethering to the political process. That's the theory. The last one that I want to mention, because it's being litigated and it's on the front pages of every other newspaper or tweet these days, is the bulk seizure of private data by the NSA and other intelligence agencies, which really is a form of privatization, as John has written about. The idea being that the government now relies on private sector data to perform its own surveillance. So the threshold legal question here is this a search protected by the Fourth Amendment? There's doctrine out of the Supreme Court suggesting it does not, because we don't have a reasonable expectation of privacy in information we give to third parties. But this is being challenged and litigated on the theory that metadata is just different, right, than putting something in a phone booth, for example, or collecting information from a phone company. Last point I want to make about constitutional litigation is the question of standing, Article 3 standing. So to the extent to which these issues are litigated in court, it's of course a lot easier for a disappointed bidder to a contract to demonstrate injury in fact. It's going to be harder for an interested citizen to sue the government over the decision to outsource in the first place, because it looks a lot like a generalized grievance, which the Supreme Court has said is a barrier to constitutional standing in many areas. But this is an area where it's fair to say there's room for some creative lawyering and aggressive lawyering.
Oh, thanks so much. All right, we've each had our go at it. I think the best way to do it might be to, oh, by the way, seats are opening up. That's fine. Those of you who have been dedicated to standing, please find an empty place if you like. And we also have a list of publications. Kanya did, I don't know if it's in your folder or not, but we did list all the publications that each of us has written in this area, which might be of value to you. I'm sure that can be recovered somehow if it's not already in your possession. Yeah. Oh, so now rather than us talking to each other, let's have you. We've got 30 minutes. Let's have you talk for a little while, ask some questions, and we'll come back and do a wrap-up. Each of us will have a chance to summarize. Okay, that work? So, questions? All right, so there's one right back there.
Yeah, Dan Guttman, 3 comments that I'm sure I'm not going to eat lunch in this town, but how's the food anyway? One is, in my view, having looked at this for many years, this has got nothing to do with Reagan or neoliberalism. The problem is in this room, that the core of modern 20th century privatization is the heritage of the progressive era. The notion that government is inadequate, you need elites, like in this room, and law professors. Jumped home to me, teaching public interest law at Peking University, students say, wait a second, you're talking about private people. Brandeis, Nader, ACLU, NAACP. How can private
Dan,
people,
is this a question?
Yeah, the question is, what is the role of the progressive tradition? That's one.
Okay.
In all the things you're talking about. Don Price, first dean of the Kennedy School in '65, wrote the book that laid everything out. Second question, is there anybody on this panel that believes organizational conflict of interest or inherently governmental policy is anything but a fig leaf? third question is, you're lucky you got contracting. What happens when we have no contract, no privity? So you've got no government claim, as in supply chain regulation. Where is the thinking where there is not the benefit of a public document, but the de facto regulation is by private entities?
Okay, thanks a lot. Let's take a few more questions, and then we'll have some responses. Over here.
All right. Thank you for coming out today. Thank you for taking my question. For me, the issue of privatization of government has always been tied to this increase in private capital and the idea that there's an increasing inequality in this country between the haves and the have-nots. French economist Thomas Piketty wrote the book Capital in the 20th Century, which I'm trying to mull through this summer. And he talks about the shocks to capitalism that happened in the 20th century, World War I, World War II, Great Depression, that shocked private capital, allowing public capital, the government to own more utilities and whatnot, and how as private capital has reconstituted itself, that as a result, private capital has diminished. So I was wondering if you could talk about the intersection between privatization of government and increasing inequality.
Okay, thanks. Let's try a few more, and then we'll right back here, ma'am.
Thank you. This is mostly directed at Professor Seifter, but I'm kind of curious, your comments about the design of the system really raises the question, who is doing the designing? What are the processes by which we develop and institute these models? And just one example that's come to mind, the California carbon market is a really interesting study. There are some success stories, but also some very serious flaws in the design that many think may come from the fact that you have scientists on the one hand delegating to economists on the other hand, with a vacuum between the two, no communication, and oftentimes the only parties that can step in and provide policy design and policy models are the private entities that stand to benefit from the system. And that seems to be a common problem. So I'm just wondering if you can talk a little bit more about perhaps the processes that produce them as well as the outcome.
All right, one more and then we'll break. Yes.
On the experience of traveling here, a TSA agent was delegated to move people who had bought first-class tickets into a fast-moving line, and those who bought coach into a slow, long line.
Does anybody want to represent?
I hope they did their job well. Okay. So let's start off. Maybe you want to respond precisely, but who has read Piketty's book, by the way, in the room? No? Any? Oh, there are a few. We'll come to that later. And then Dan's questions. All right, go ahead.
Do you want to do the directed question?
Yeah, I thought we'd do.
Yeah.
Miriam.
Back to the mic that doesn't work.
Oh, here.
Tap.
Here, you're good. Here, you get two mics.
Okay, well, one of these is going to work. So it is an excellent question, and really, I think you put your finger on part of the problem here. I mean, I can say that in the program that I studied, there was actually a state statute that had been crafted to facilitate this transfer to private power. So, I mean, I guess one way to look at that, though, is pessimistically. Even in what ought to have been the most sort of publicly informed representative process for devising a privatization scheme, it still, like your question suggests, is these sort of private entities who are the most informed, the most involved in the sort of lobbying process. And I think you might see a mirror image of that if there was a regulatory process that was going to sort of devise the privatized program. You would see the sort of, usual suspects of interest groups who are lobbying for the program to look the way they look. So, I mean, what is the answer to this? I think there is no easy answer except to say that this is an issue that requires a lot of sort of public oversight and a lot of citizen attention and watchdog group attention to figure out how the incentives in these markets are going to run, and then also to try to have the process be iterative, so that if there is the problem, like sort of the one that my study pointed out, the one that you're talking about in the carbon markets, there's some subsequent follow-up process to redesign.
I think you have to assume a couple of things, and we always go to these conferences and people say, let's rewrite the regulations, let's make the system better. You got to assume a couple of things. There's not enough regulators to regulate anymore, right? We live in a global economy. When I was involved in the SEC Dodd-Frank rulemaking, Mary Shapiro is sitting across. She said we have like one examiner to every $12 billion in assets. And the FDA now has to send investigators or agents to China to look at how drugs are being produced, let alone tested in 3,000 trials. So forget it. You don't have enough staff, right? So the question really is citizen oversight, right? And by the way, you can take any one of these contracts, thousands of government regulations from wage and hour to organizational conflicts of interest. Nobody reads that stuff, and the contracting officers don't read that stuff, and some of it they think is completely immaterial. The opportunity for this group is to take the Veterans Administration situation and say, who's responsible for that? Is it the government, or is there a contractor involved in that? And what does that contract say? And if it's not in the contract, what do the regulations say? Because the regulations are presumed to be in the contract. That's the litigation opportunity for you. And then figuring out compliance enforcement strategies, whether it's the False Claims Act. A lot of the substantive regulation is there. What's missing is compliance enforcement. What's missing is understanding where the private sector is involved. That's the opportunity for this group. And if you start generating that kind of dialogue and bringing those kinds of lawsuits, the transparency through the discovery process, right, will actually generate perhaps oversight, perhaps additional regulation, and setting a standard. The contractors are going to game the standard. Quick anecdote. A number of years ago.
Come on. No more anecdotes.
Okay, well let's finish.
Let's turn to the
The point is, the
next
contractors will game the system. If you give them the standard to interpret it, they will interpret it to their benefit. Period. That's it.
Right. You wanted to do the Piketty one?
I'm going to actually try to do Dan Piketty's friend and TSA, all under the same rubric, because I think they tap into a similar set of issues, if not perfectly directly. So the progressive tradition. So what happened? Are we the kind of inheritors of the progressive tradition? I would say the answer is yes, but there's an important kind of moment in between that we've lost sight of. So the tradition that you're citing, Dan, is in large part a kind of pre-modern administrative era of the 20s and the 30s, and it got into the New Deal. But by the 1940s, the 1920 civil service was not the same thing as the 1940 civil service in terms of size and scope and professionalism. And I think we wavered. So we set up a system, and then we wavered again in the post-war era, which you've written about, when the Rand Corporation and other new elites came back into the fold and said, we can do this better. So I do agree that this is a recurrent theme, but I do think that there's a moment in between. It might be a short one, but for me, at least, it was a sweet moment in which we really fully try to internalize as much as possible within the governmental sector. And then again, and this is why I do think it speaks to questions of, if not inequality, about just, again, our kind of general orientation in favor of kind of business know-how, and we can get things done because Lockheed Martin can build, wonderful, fighter jets, so they can also administer, because they've set up the same data analysis system, welfare administration in many states. And that, to me, is maybe they do have the kind of technical expertise to do it, and they've done the work. But I think it speaks to a similar understanding and orientation that the business sector, the business community, or people with special expertise don't have to invest in the government. They can come in, swoop in, and do their work. Now, to the extent this relates to your experience, I guess what you might be tapping into is a concern that we're moving away from a general public service and more towards a user fee system, where there's a two-tiered system, as it were, in this context or in any other context, in which you could pay more than as just a general taxpayer to get services facilitated, either in an expeditious fashion or the only way possible. And I do think that taps into a sense, again, of an erosion of a shared collective sense of we're all in things together, and it speaks to the kind of proliferation of moving away from general services and more towards user fees, which has always been part of the American tradition in various ways, but I think it's intensified, particularly as in a response to or as a function of anti-tax backlashes and the kind of gating of American communities. I do think this all taps into similar notions about somehow the kind of the esteeming of the private and creating your own sense of community as opposed to necessarily the one where we're happen to be jurisdictionally committed to or constitutionally, complicit in.
Okay, so let's get a few more questions. Over there, if you can reach over there, and then right there in the middle, and right over there. Three hands.
I'm Dr. Caroline Poplin. I work with Reuben Guttman. I was a Fed for 22 years. I was at EPA when Reagan said, government is not the solution to the problem, government is the problem. My question is for Paul. Are you concerned about the incorporation of business techniques into government? I think that's where the VA scandal came from. Incentives were set with financial incentives for getting waiting lists down to 20 days. I think that's happening throughout the government, was encouraged by Clinton. And is that part of all this?
Thank you. That's a good question. I'll hold it, though, until we get the other two, and then we'll respond.
Thank you. Thank you so much. So my question is just about, it's for all of you, and it's about how what you have been saying applies to nonprofit service providers. And so I would give you two specific sort of streams that you could use. One would be social impact bonds and nonprofit service providers who are trying to achieve social outcomes and then being paid by the government for that. Or another potential mode of analysis would be charter schools and the issues that they present in terms of incentives, in terms of regulation, and then in terms of the interesting point you raised about shared collective values. Thank you.
Sure. That's good. One more.
Thank you. I was wondering if you could speak some to the risks of these creative lawyering calls. I mean, you talk about private prisons and national security contractors, and I'm thinking it sounds just like a Federalist Society panel, except they would talk about Peekaboo and the Financial Stability Oversight Council and others. And so I'm just interested in the risks of using the appointments clause, delegation, and other principles.
That's very good. So you're going to have to defend yourself over there. All right. So let me take. Let me take the first question, Dr. Poplin, about use of business techniques in government. If you were in government, you're right. When it was declared that government is the problem, not the solution, you were at EPA. So I'm not a. Let me say how I try and position this in my own thinking, both before I came into government and since I've been here, and that is that I do think business techniques can be useful. I believe that during the Clinton-Gore years, when they came up with reinventing government, they tried to create, there was this phrase going around, government should steer and not row. That is, the hard decisions should be made by government, but implementation, in Miriam's terms, once you have a structure set up, a design, then you let others could implement it. So in that sense, that seems like a business technique that I favor. I favor management that gets it right the first time. I don't favor litigation, by the way, Reuben, as a solution to government management. It comes too late, although you should learn from it, certainly. Now, the problem has been, quickly, that in the VA, as in other situations, they give incentives that are impossible to perform. When you say, you have to see all your patients in 14 days, well, what do you think is going to happen? This is freakonomics, isn't it? It's like the Chicago school system where they said, okay, you get your bonuses are going to be based on your performance of your students. Well, that's when they started erasing the answers and filling them in, right? You can't give incentives that are impossible to comply with. So part of the problem is that. It's not that the incentives are wrong. It's just that how you employ them, you got to think it through. And so I wouldn't want to throw business techniques out the window as a way of solving a problem. The biggest problem for government is that talent, and John referred to this, the talent, the permanent talent is shrinking. SES folks are all at retirement age. It's very hard to keep the talent flowing, and frankly, Unless we do that, Francis Fukuyama, who you may know about in a lot of different ways, recently spoke to our plenary session about the need to have quality government. You know, it's not the size of government that's the issue, it's the quality of government. And he compares this to all Western countries, and we're behind in that quality. Now, the problem is the president gets in office, has good intentions, and they all want to make sure the government works, but then before you know it, they're on to other things. And the sustained power to really focus on quality hasn't been there. So, next question was who is that? Social impact bonds. Did you, I can do that one too, but I don't want to keep talking about it. Or you want to do it?
Well, you know, the charter school question is really interesting. Arne Duncan has about $3 billion scored in the Department of Education budget for charter schools. And there's no mechanism to really monitor how that money is being spent, and it's haphazard. And you start off with the premise that, you know, because it's private, it's better. Well, why? Why is that true? I mean, you've got Joel Klein, who was Chancellor of the New York City school system. Clearly, you've got smart people there. The sort of other part of that is we're seeing that in the for-profit schools. You have all these distance education schools, that you learn over the internet. There's a ton of government money involved in that. And the way those schools are licensed by the Department of Education is not directly by the Department of Education. The Department of Education, through their regulations, notes entities, associations that approve these schools as being licensed entities. And the way these licensing agents get paid is their revenue streams come from the schools, right, that they license. And the more students they have, the more amount of money they get, right? And nobody's actually backed into this and looked at, you know, how are you actually overseeing compliance or, ensuring quality education and that the money is being spent appropriately. So yes, it's a real problem. It's not just a problem with, for-profit entities are doing government business. It's nonprofits as well, or entities that are acting under the guise of nonprofit status.
I just want to make one thing about social impact bonds. To me, this is a very fascinating development that the private sector, and this is happening, if you look, Rockefeller Foundation has a big program in this. You can go on the website and see. It's now a market in London on social impact bonds I really see this as it's sort of a compromise, public-private thing, but where private money is invested with a secondary rate of return notion, where you can actually make profit and do well at the same time. And to me, that's a very optimistic and positive development. Okay, the third question, do we have? That was yours, actually. You got to defend yourself. That's a very sort of sharp retort there.
So the gist of the question was, how does the appointments clause bear upon private actors because of separation of powers?
No, I understand how it bears on it. It's just a technique that the Chamber of Commerce.
She's worried that you're going to become the Federalist Society if you do that.
I guess I need to understand that a little better as far as you're concerned, because I'm not familiar with what the Chamber of Commerce is doing in that regard.
Sure. So originally, the definition of an officer, about whether it included contractors or private actors, the kind of initial push on privatization happened in Bush 41, senior Bush, right? And now, since then, the Republicans and Democrats have kind of taken contractors out, right? If you delegate to contractors, they're not officers, you don't have an appointments clause. But the Chamber of Commerce is kind of coming back to George Herbert Walker Bush's OLC definition of officer, and they're pushing these appointments clause challenges to entities I think the ACS would like. And so you made a call to students and lawyers here to use what I think of as the same techniques for entities that you're more concerned about. And so I just wanted more reflection on that.
Well, I guess I'm not saying in particular that any given contractor should be treated as an officer or not. I was laying out the possible theoretical options, the doctrinal options for challenging that. So it's hard to answer that not having thought through the particular context that you're mentioning. But I do believe that there is no one minding the constitutional store on this, and that there is just a sort of a primal almost belief on my part that the Constitution has to have some role in how government is structured, particularly if civil liberties are affected and the people's power, which is really just the Constitution is a conduit for the power of the people. It doesn't somehow just morph into something private because some contractor decides to create some alternative arrangement. So that's something, it's a great question. It's something I would really need to think about with more care with respect to the policy implications of it in a given situation. But given that there isn't any overarching doctrinal rationale for challenging outsourcing, one of the available hooks is to utilize the court's Article 2 and Appointments Clause, Take Care Clause, Vesting Clause cases in the context of independent agencies. So I've written about this notion of a spectrum of public versus private, the idea being that when Congress creates an agency and makes it independent, takes away the president's ability to hire and fire, creates multiple agency heads that have staggered terms so that no president can come in and throw them all out, that they're really designed to limit accountability. When Congress messes with that structure, the courts come down pretty hard on that, on Article 2 grounds. And in a case called Free Enterprise Fund versus PCAOB, made an argument that wasn't a strict appointments clause argument regarding whether someone's an officer, principal, or an inferior. It was really using the Take Care Clause and the vesting clause to argue that there has to be some level of accountability. It can't be so attenuated that the president really has no control over those who are exercising his power on his behalf. So it's that line of thinking that I think can be adapted to the outsourcing context because the premises behind it are the same. The idea being, on the other end of my spectrum, why is it that a lower level, procurement officer enters into a contract and hands off the same power that maybe the Congress vested in the PCAOB, and hypothetically, and all of a sudden there aren't any constitutional concerns about it whatsoever, even though the same questions of accountability are in play. So that's really what I was getting at, not versus the specifics of is someone an officer or isn't, but that's a really good question.
Okay, we've got a few minutes, and I think everyone should get a final word. But on the officers of the United States point, though, I think that's an important idea and concept. I think at some stage that's what inherent government functions is about, that officers of the United States must perform inherent government functions. There's a little-known statute called the Subdelegation Act, which was actually a product of the Hoover Commission in the 50s, which says the president has the ability to delegate without congressional approval but the limit is to officers of the United States, so that the White House can reorganize, or could under that statute. That's no longer the case. It could reorganize, but they have to do it. They can't give it to contractors, in other words. That being an officer of the United States, swearing the oath is an important step, and you have to draw a line there, at least when it comes to management of government, that you want people in charge who can manage the government. So, let's see, how about final words? You want Miriam, and then we'll work down the table.
Mine will be very brief. I think this discussion has been illuminating, and one way in which it's been illuminating is to think about all of the different kinds of forms of governance that may be problematic. So it's not just your classic sort of military contractor that raises concern. It's potentially charter schools. It's potentially programs run by nonprofits. It's anything really in this sort of privatized world that may be a vehicle for underperformance of government. And I think the sort of takeaway from the way I approach this is that really it's the design of those programs that can tell us a lot about what to expect from them. And with the sort of pervasive presence of the profit motive, it's critical to think about how to structure incentives to make it more likely that a privatization program will work the way that the government and people want it to.
I guess I think my takeaway is that A, privatization is pervasive, you've got to identify it. B, the actors, because they're human, are going to want to game the system. C, it's virtually impossible to have enough government folks to enforce compliance, and Paul and I somewhat part ways on this. I think that litigation is an absolutely necessary component of our compliance enforcement process. That's why we have citizen suits provisions in all our environmental laws, going, 42 U.S.C. 1983, we bring 1981. Congress anticipates that we're not going to have the ability as a government to enforce, and we need the citizens to help. And the challenge is, this is what this group can do. You can actually get involved and look at these privatization entities and where it's being privatized and think about whether the contract or the regulations are being honored and bring litigation. John Lewis, when he talks to ACS, says that that's the power that you have as a lawyer, that you can actually make a change incrementally by going to court. And that's what I encourage people to do and think about.
Okay, John, I don't.
Just a couple of points to tie it together, some loose ends. Just to echo Reuben's point about design, all of this costs money. So if we said that if we just put more resources into it, it might undercut the very motivation for privatizing in the first place. So I've seen numbers that it's 20% overhead to on top of whatever the price that the contractor is giving if you want to properly manage a government contract. So that's a problem. Another problem on the other side of it is that we talk about competition, and if there's more competition, competition, as I think Kimberly mentioned, is also problematic because it means those folks. It might be good on the efficiency side, but it's bad on the we're way too loyal and we're not going to push back on really bad ideas front. You can think about the credit agencies in the last decade, and that if you want to curry favor with a client and there's others who also want to curry favor with the client, well, you're going to be as kind of solicitous as possible. On the social impact bonds, my big concern there is the high risk, high reward element of it is that because you're not, the contractors get paid usually some kind of cost plus or a flat fee. Here you're going in sometimes all or nothing or 50%. So if you don't do well and you see that the kind of writings on the wall, there's kind of moral hazard concerns to bail out, and the government has the kind of probably imperative to come in. So I think those need to be studied much more carefully. And on the point about whether litigation is good or bad, I agree. I think we're seeing today that similar undercurrents in even in non-privatization cases where some of the justices are complaining about the overgrowth of the administrative state. I would say the same thing about the APA, though, that you could be worried that regulated special interests are just using the APA to slow things down. But do we want to cut off that channel because also kind of consumers and aggrieved citizens also? So I think it's a complicated question to answer.
So, final word with respect to the Constitution. I agree that litigation is important. Constitutional litigation is important. One thing that came out of today, a tapestry of forces have to come into play here to start remedying the issues. I wanted to highlight the question of civil liberties. Due process, I mentioned the Lockheed Martin example. Of course, TSA came up, right? Groping by a TSA agent is different from groping by a private contractor. 17 airports in this country are now managed by private contractors. Fourth Amendment, 24-hour surveillance, right? It's all driven right now, or largely driven by private sector data. The line between the public and the private sector is illusory. It's a fiction, but it's embedded in the doctrine. And given the implications on individual civil rights and the lack of transparency, which I think we might all agree under the FOIA and other ways is a major way in which we hold our government accountable, there is a role for constitutional litigation.
Great, thanks. So, well, let me just say a few words about the people in government, since I'm actually doing this. And to me, none of this matters unless you have people running the shop who know what they're doing and are dedicated to it. And there are a lot of those in government. We see them all the time. The administrative conference is, in fact, a conference of senior government officials. In fact, we've got Alan Morrison here, and I see Jillian, two of our members, who either have been in government or know a lot about government. And I see them all the time. I see government servants at work, and they do a great job. On the other hand, we desperately love contractors, because most of our research is done by contractors. And any of you who want to become a contractor, all you have to do is go on our website. We're looking for really smart people who know answers to questions that we don't. And I think contractors and government have to work together. I mean, it makes a lot of sense. You don't want to build in all the expertise in the world. If you can get it an appropriate way. Look at the scientific community, for heaven's sake. We couldn't ever duplicate that and shouldn't. So it's a bit about having people in charge who are officers of the United States, who know how to run the government, and supporting them, which is one of the big problems today, especially, as I suggested at the outset, at the state level, where the value of civil service is being repudiated on a regular basis. Those are my words. Thank you so much.